afternoon, everyone. Andrew Blundell here from Cathro & Partners with our now 5th episode of The Cut. This is the first time Simon's vacated the chair, so I'm now in the hot seat. He's up in Byron Bay today taking care of an energy retailer with some of the team. Today's guest, I'm sure, is going to help me out with that. It's Mr. Farid Assaf, SC. In terms of Farid, his background, he's a commercial silk with extensive experience in corporate insolvency, cross-border insolvency, company law, banking and finance, corporate reg matters. What don't you do, Farid, when it comes to that side of things? He's a fellow of Insol, has written 2 go-to books on insolvency matters, which we'll touch on a bit later. Prior to being called to the bar, he was an in-house lawyer with the Australian Securities Investment Commission. Simon and I both obviously work with you, Farid, and you've obviously been kind enough to join us today, so thank you very much and welcome.
It's a pleasure. Thank you for having me.
Oh, anytime. Obviously, storied history. You've been in and around insolvency via ASIC, now obviously at the bar. How did you come on this journey to be Mr. Farid Assaf SC?
Look, you sort of fall into these things. I never really, when I started my legal career, I didn't say I'm going to be an insolvency lawyer. What I did know, though, when I finished uni was I did want my career to focus on corporations law.
Yep.
When I was at university, I got a taste of corporations law. I for whatever reason, I enjoyed it.
Yeah, for sure.
And then fortuitously, when I was, would you believe, backpacking in the late 90s around Europe, I bumped into a guy who we eventually became friends who worked at ASIC at the time. He was a paralegal.
Wow.
And we actually ended up travelling to Morocco together.
It sounds very similar to the way that I became an insolvency practitioner. It's
just these things, you know. You just bump into people who, I mean, he basically almost, I suppose, changed the course of my career.
For sure.
In a sense, because when I got back to uni, there was a few months when I got back, there was an advertisement on the notice board there, the uni notice board, and there was a paralegal position at the then Australian Securities Commission, the ASC.
Yes.
So I rang my friend, and he said, "Yeah, I know the lawyer who's responsible for that. I'll put in a good word for you." Next thing you know, I'm a paralegal at the ASC.
Wow.
Working on, it wasn't the most glamorous jobs. I remember my first day was literally photocopying a trolley load of documents.
That sounds like everyone in the 80s, Farid.
But mate, you know what? It was that first day, I thoroughly, it was one of the most enjoyable days of work that I've ever had because it was the first office job that I've ever had.
Yeah, right.
I got to wear a suit for the first time. So
you scrub up all right too, so that's good.
It was just, you know, it's one of those things where I was actually very grateful for the opportunity, notwithstanding all I was doing was standing in front of a photocopier.
Yeah, it's amazing that those small things leave such an impact on you, right? It's similar to me when I first started in my insolvency career. I fell into it. I was trying to be a marketing guy, not a liquidator. So just happened to apply for a marketing job with the insolvency firm. Didn't get that job, but they said, well, why don't you come on and learn the ropes? And here I am 20 years later as a liquidator. So it's one of those things where, like you said, you know, sliding door moments in life that lead you to where you've got to today.
Indeed, and I think we've all got those stories. So it's just very interesting. And so from there, I spent, it was probably about, it seems like a longer time now, but looking back, it actually wasn't that long. I think it was about eventually 5 years all up at the commission, 2 years post-admission. So most of it was part-time during my legal studies.
Yep.
But during that time, even as a paralegal, I was lucky enough to get exposed to almost all the different aspects of the ASC's, you know, regulatory business.
Yeah.
Including one of the areas I enjoyed the most, and people don't often hear about this, but the commission has what's called a policy section.
Right.
And when I was there, it used to be called the Office of the Chairman, and there was a distinction between the what we call the regional officers and the Office of the Chairman. I'm not sure if that distinction still exists, but when I was there, certainly the Office of the Chairman was actually, they were physically located, I think they were in Chifley Tower.
Right.
And it was, as the name suggests, it was where the chairman of the commission and the senior commissioners sat, and they together with the policy making arm were responsible for developing what used to be called the I think they were called policy statements.
Right.
They're now called regulatory guides.
Mm-hmm.
But the ASIC policy statements, you can see, if you know, I'm sure you've come across a lot of the regulatory guides.
Yes.
They're actually significant pieces of work. There's a lot of intellectual input that goes into developing those policy statements.
Yeah, look, even from my perspective, obviously there's an RG statement for becoming a registered liquidator, and that's pages and pages long, and obviously sets out what bars you need to meet to become a registered liquidator. And
Indeed.
you can see the time and effort that goes into those particular statements. So that, amazing that you had that experience.
Yeah, so look, and although they don't have the force of law, they're still influential, as you know. So the market pays a lot of attention to them.
Absolutely.
And even courts do. The courts make it very clear that they don't have the force of law, but they still carry quite a bit of weight.
Yeah, right. Now, in terms of obviously ASIC regulatory side of things, now you're an SC and working on some pretty interesting matters. So tell me about the process of getting from being the in-house counsel, in-house lawyer at ASIC to now becoming an SC. How did that journey kind of start?
Yeah, look, it was an interesting journey, and again, just meeting people who happened to change and happened to change basically really your destiny, or perhaps instrumentally your destiny, if you believe in that kind of thing.
Yeah.
But certainly, I just met key people along the way. So, for example, when I was at ASIC, I met a then junior barrister.
Right.
And he encouraged me to go to the bar. And looking back at it now, if it wasn't for his encouragement, I probably wouldn't have gone to the bar, or wouldn't have gone to the bar as early as I did.
Yeah.
And I ended up going to the bar when I was 28.
Yeah, wow.
So
Mate, I still hadn't.
It seems like a lifetime away, and it is a lifetime. But at the same time, it seems like it was yesterday. And I'm sure you probably have the same experience.
Yeah, I didn't quite get to my level as early as you did, but I know Mr. Cathro will be wondering, well, hey, there's someone here that got to where they are now at an earlier age than him, so I'm sure you can have a battle about that at some future point.
Right.
But yeah, it's I did my CPA, became a registered liquidator nearly 3 years ago now, and it took me a little bit longer in terms of trying to decide what I wanted to do. I started in insolvency, worked in a small mid-sized firm now that's for 7 years, rose up the ranks, became a senior associate there, and then had the opportunity to go to America and do something different for 5 years. And at that point in time in my life, I was 30. That was something that kind of piqued my interest. So I went and did that. I had an interest in a business I sold, worked in California for a while, New York for a while. And I'm really glad that I did that, because it rounded my skills in terms of what I now do as an insolvency practitioner.
Yeah, it's brilliant. Every experience, whatever job, regardless of how modest and how humble it is, you learn something from it. So
absolutely.
I actually started working when I was basically a child, because my parents had fruit shops and grocery stores. So I started working for as long as I can remember. I've been working
in the family business.
In the family business, and when I left, during the family business, we actually went through one of my most influential moments in life was the late 80s, early 90s, when we experienced, and you probably remember this, the recession that we had to have.
Yeah.
Right? So, when you had sky high interest rates, you had interest rates in 17, 18,
I think
20, low 20s.
Mum and Dad's mortgage was about 120 grand, and it was 18.5%.
Yeah, it was an extraordinary time. So one of the things that I had to do was to support the business. I actually went working at, I don't know if you remember Sizzler.
Yes.
I worked at Sizzler washing dishes.
You got to do what you got to do.
Did these things, but it was great fun. I just rolled my sleeves up and got on with the work.
Well, that teaches you work ethic too. I
Indeed
swept
does.
floors at McDonald's for years to put myself to a point to get to university.
Yeah.
So, all of those formative experiences obviously build you into the person that you are and help you along your journey. I guess.
Indeed. And after that, I even became a removalist for about a year.
Oh, how good. Farid, taking the couch up the stairs.
I tell you what, I take my hat off to removalists. It's one of the hardest jobs you can ever do.
It definitely is.
Especially in the heat. It's a really tough job.
Did you break anything? Now that's
I don't think I did actually. No, I'm pretty sure I was pretty careful. I'm sure I was accused of breaking things, but I don't think we actually did. No, but So again, you just learn things, and you meet people, and you're constantly learning.
So you met this guy. He said, "Hey, you should become a barrister." How did you go about it after that?
And then next thing, well, how you go about it was the process of becoming barrister is it's a little bit odd. It's not like any sort of other profession, but look, that said, it has a lot of similarities. You just a lot of it with me had to do with knowing people. So I put in an application form.
Right.
So every year, a floor will invite budding barristers, junior barristers, to become what's called readers.
Yep.
That's an archaic system which dates back to the apprenticeship system in England.
Right.
And basically, you become an apprentice barrister.
Right.
So for your first year, you become what's called a reader, or basically an apprentice. And once you're admitted, you have a limited practice certificate.
Mm-hmm.
And you read, that's the expression that's used, you read under your tutor or pupil master, as they were known.
Yep.
And they basically take you under their wing. You're still a full-fledged barrister, but with certain limitations.
Sure.
This particular barrister who I became friends with took me under his wing. He said, "Look, why don't you apply to the floor that I'm on?" It was a good floor, the 12th floor, Selborne Wentworth Chambers.
Yep.
And next thing, I put the application form and I became a reader. So it was very fortunate to have had that opportunity.
Yeah.
And from there, I just got to know all sorts of
good, wonderful people,
great people.
Yeah.
I was very fortunate to have been on the floor at the same time as judges of, in particular, the federal court.
Yeah, great.
They're now judges of the federal court. So I was very lucky to be able to work with and work alongside of those kind of people.
Yeah.
It really was an extraordinary opportunity, and certainly an eye-opening experience for someone like me who had no relatives, really knew no one in the law, and had quite a modest background. I actually grew up in Cessnock.
It's a great part
in
of
the Hunter.
Hunter,
It's booming now, but certainly when I was there, it went through some tough times because traditionally it's been a coal mining area. But now it's transformed itself, as you probably know. Whenever people think of whenever you say the Hunter Valley, they instantly refer basically to Cessnock Colburn area.
Yes,
which of course is the wine growing region, and that's done exceptionally well over the years.
Wonders.
Yeah.
So fruiterer, removalist, sizzler guy.
Now I've done it all, mate.
He's a lawyer.
That's right.
Barrister. So from barrister, you're a reader. You're getting that experience. You get to a point where you've got no limits on your practicing certificate, I suspect, and now you make the decision, well, how do I now move from being a junior barrister at that point to be the SC that you are today? So how did that all come about?
Yeah, again, look, by the time I was probably about 8 or 10 years, you have to start making a conscious decision as to where you expect or where you want your career to go. You can never really dictate where it goes, but you can certainly take steps to try and steer it in the right direction. And whether or not you're successful or not is another matter, but certainly you can make deliberate decisions which hopefully have beneficial long-term consequences. What I did, one of the things that I did, rather presumptively or presumptuously, was I thought I'd just write a book.
I thought we were going to get to that point and that was the segue I was hoping for. So well done.
Again, very presumptuous of me because it was interesting. Again, one of the cases that I started, or the cases that I started getting, and you get these cases as a junior barrister, these applications to set aside statutory demands. And they're good cases. They're great cases for barristers, junior barristers, especially to do because there's many cases.
Yeah.
And so you can end up in the Supreme Court, Federal Court over relatively, modest amounts of money, or sometimes not so modest amounts of money. But the issues are relatively confined. But that said, there's still I wouldn't say a stat demand case is straightforward. Sometimes some people may disagree, but they certainly can involve issues which can be quite nuanced and indeed quite complicated.
Well, and there's so many, the process in itself of getting to a point of serving your statutory demand and what you need to include on it, there's so many places and traps for young players in terms of you put the wrong piece here or you don't put that there and it's invalid. And then obviously you get to a point there where you go, oh, well, that's invalid because of X, Y, and Z.
That's exactly right. And one of the things that when I started doing these cases, you start as a barrister, especially as a junior barrister, you start reaching the case law. And one of the things that I discovered was there's actually no book dedicated to what is actually, it's one of the most litigated areas of corporations law, as you could probably imagine, because there are so many cases. There are literally thousands of cases, not just on statutory demands, but also winding up, which has, again, literally thousands of cases. And we're talking about winding up in insolvency.
Yep.
And again, it's a very technical area, but a very important area, as you'd appreciate.
Well, it kind of gives that substance to the system because there's got to be a process to push people to get to a point where they're responsible for the debts that they've incurred.
Indeed, and what the statutory demand process was always intended to be was basically an evidentiary tool which can be used to establish insolvency. It should be. Not always is, as you know, an easy way for a creditor to be able to establish insolvency with a view to commencing a winding up application.
Yeah, and you're right. It's not always clear cut or straightforward, but the intention's there, and obviously that provides some certainty for people that are doing business in the country too, and it's an important part of the system of enforcement.
Indeed it is. And interestingly, when I started writing the book, again, I had no idea what I was doing. I had no idea of the magnitude of the topic or topics that it entailed. I just thought it would end up being basically a few hundred pages, just a quick guide, almost like a running commentary.
Sure.
But the obsessive compulsive streak in me just realised that there was a lot more to it than I initially had anticipated.
Yeah.
And it just ended up growing and growing. And within the whole, although it's ostensibly the first book rather was just really focused on statutory demands and applications to set aside, although there was a section on winding up, of course.
It is the preeminent book in that space. I know.
I think it's the only book. So
well, there you go.
You soon realise that these stat demand cases actually traverse a lot of different topics. So you'll have topics, obviously service. I think you've already service. There are also all the formal aspects.
Yeah.
There are the more substantive aspects of it. So, for example, what's a debt?
Yes.
When is a debt due and payable? And the question of what is a debt is actually quite a complicated issue, and there is a lot of literature and a lot of learning on what a debt is, and I won't bore you with the details, but it certainly has, for example, in our legal system, it actually has quite a long history, and that's something that I enjoyed exploring in writing the book. But also it covers different industries. So, for example, in building and construction, when you issue a stat demand in that context, you need to understand legislation such as the Security Payments Act, which in itself is a complicated area.
Well, it's another enforcement tool too.
Indeed,
it's all very fascinating from that side of things. And I'm glad you wrote the book, because I don't think I'd have the patience to go through the thousands of cases that you did. But obviously that set you up to be at a point where you became a silk.
Pretty much. So what then happened was I started obviously getting a lot more insolvency cases. I ended up having the opportunity to end up in court a lot more, doing more challenging, more interesting cases. Eventually you reach a stage where you're lucky enough to have your own juniors and you're running cases not only by yourself but also with a junior barrister, and you end up basically running a legal team.
Yep.
Which as barristers is actually quite refreshing, because being a barrister can actually be quite lonely.
Quite lonely, yeah.
So it's actually and one of the things I enjoy about being silk is being able to work with colleagues and manage a legal team.
Yeah, amazing. So working on all these fancy cases, what in your view, top three, let's say.
Top three cases. I'm glad you asked.
What would they be?
Look, obviously the most recent one would obviously be the CADIC matter. That I did last year. I was acting for the commission.
Yep.
Essentially, although we were seeking certain orders against Melissa Caddick and her company Malavar.
Yep.
And the orders we were seeking, they're actually quite extensive. We were seeking about 20 or 25 prayers for relief. But essentially what we were seeking was a declaration that Melissa Caddick and her company had contravened the Corporations Act by essentially operating or providing unlicensed financial services advice. And an order that the company Malavar be wound up. And also an order that, and this is the most important, probably the most important part of the orders that we were seeking, was that a receiver be appointed on a final basis to be able to identify and essentially call in all of the assets that the receiver had identified, sell those assets, and then distribute those assets to identified, what we called investors.
Sure. So they'd gone in, they'd figured out, well, the diamond ring or the necklace or the pair of shoes or the hairdresser's car were all bought with the proceeds of investors' funds.
So what happened was initially interim receivers and provisional liquidators were appointed. It was Bruce Gleeson and Daniel Swar from Jones Partners, who I'm sure you know very well. One of the tasks that the court gave to them and required them or empowered them to do was to investigate and prepare a report to the court identifying who the investors were, identifying the monies that they had paid in or paid over to Caddick and to Malavar, and also conducting a tracing exercise to find out where the money eventually ended up.
That's gold stuff for someone like me. I would have loved to.
You would have enjoyed it, and to Bruce's and Daniel's credit, they did an excellent job in quite trying circumstances in seeking to perform all of those things, undertake all of those tasks, and we got to the point where there was a report that was prepared, and it was quite clear what had happened in my view. And this is all set out in the judgment, so it's all public knowledge now. But when you read Justice Markovich's judgment, you can see quite clearly what happened. And it's pretty much what has been described in the papers. It's actually quite accurate.
Wow.
Because I think what has happened is the journalists themselves listened in on the proceedings.
Right.
And they've obviously read the judgments.
Pretty close to.
And the judgment was very detailed, and it's set out in quite some detail as to what actually happened.
Yeah, right. Yeah, no, very interesting case. Obviously, the foot washing up on the beach down the south coast is added to the mystique.
Oh yeah, it was obviously a terrible turn of events. Obviously, it's a terrible case from a human level.
Yes.
And in particular, especially the people that invested. And you can obviously read all about it. I mean, there's another podcast
Yes,
I understand that deals with those issues. But yeah, there's certainly. At that human level, there are many sad stories.
Oh, absolutely, and obviously the investors and the people, the family, the friends, all those people that ended up being caught up in the Ponzi scheme are the ones that unfortunately have to pay for it and live with it.
And you mentioned Ponzi scheme. That's precisely what it was. One of the challenges that we had was to convince the court that. In relation to the assets that were identified, and mind you, most of the assets, this is what made it quite difficult and quite challenging.
Yeah.
The main asset of the company were the motor vehicles. So it was an Audi and a Mercedes.
Yes.
That was actually quite easy.
Yeah.
Because that was it. So the provisional liquidators and liquidators at the time said, okay, well, these are the company's assets. We're selling these. We'll take the net proceeds of sale and we'll distribute it accordingly.
Yes,
that's easy. If the assets were in the company, it would have been a lot easier. The problem was most of the assets we're talking 95%,
Yes.
were in the name of Melissa Caddick personally.
Right.
And so the challenge that we had was, well, on the one hand, you say, okay, it's an individual who's missing, and they're a missing and or dead. Again, that was the other.
Well, we don't know definitively.
Well, that's right.
Do we?
That's right, and that was the other challenge.
Yes.
That we faced. So, what is the court to do in those circumstances? And I had to research all these cases on what does the court actually do and how does it actually proceed. What we argued and what the court accepted was to avoid the bankruptcy path.
Yeah.
Although it was potentially available. And we argued, and the court agreed, that the court had the power under the Corporations Act to basically put in place a regime whereby the receivers had the necessary power to call in all the assets, sell the assets.
Even if they were in Caddick's name.
Even though they were in Caddick's name.
Yeah.
Call in the assets, sell those assets, and at the very least, prior to any distribution, ensuring that the proceeds were deposited into a separate and discrete bank account.
Sure.
And there could then be a process whereby any interested parties could be notified that this is what had taken place, that the assets have been identified, the proceeds of sale have been deposited into this account, and that the receiver was minded to make a distribution along certain lines. And if the interested parties were so inclined, they could come to court and argue their case as to whether or not they agreed with the proposed distribution.
Right.
And so that's the regime that is presently in place.
Which is very similar to the proof of debt process. It
is similar, but still I think on balance it's a lot quicker and I think a lot less expensive than a traditional bankruptcy.
For sure.
I could be proven wrong, but so far, so good. But
yeah, that's very interesting and obviously a very niche area of the law that you would have to spend quite a bit of time getting your head around. So.
And you, indeed, very niche and indeed very novel. I don't think there's been really any other case like it which has taken that quite, I suppose, unique, very niche approach to the relief that the court was asked to grant in that particular case. So from a lawyer's perspective, very, very interesting.
Very interesting. So that's one.
So next one. Next one I think was, again, I'll just go back reverse chronologically. The other one was another case I did last year. It was a case of Western Port Holdings, and this is probably more of a technical matter, but I think your listeners and you would certainly be interested in.
Sure.
One of the key issues in that case was I was acting for a liquidator.
Yep.
And the liquidator had sued the Deputy Commissioner of Taxation.
Right.
In respect of unfair preference payments made during the DOCA period.
I did read about this.
You probably read about this.
Yes.
It's actually quite interesting. The Deputy Commissioner argued, and you're wrong.
Yes.
There can't be any unfair preferences to the Commissioner during a DOCA period because all of those payments, this is what their argument was, all of those payments were made under the authority of the deed administrator. Which superficially, when your instant reaction is, that probably sounds right.
Yeah.
But when you actually look more closely at the actual DOCA, the deed of company arrangement, and you look at the legislation, it's actually wrong.
Wow.
And the reason being is, and you have to go back to first principles.
Yes.
The reason being is when a company is in DOCA, in most cases, if not all, most cases, the management of the company,
control
of the company, is reverted back to the director.
Practice.
So any corporate action, any corporate conduct that takes place is under the authority of the director.
Correct.
Not the administrator.
No, not the deed administrator in that sense.
And so therefore, once you accept that, and that is, it really is incontrovertible.
Yeah.
As a matter of company law and / insolvency law, it's that it really is indisputable.
Yes.
Once you accept that and you look at the docker, it was simply impossible to argue that the payments made by the company at the behest of the director were under the authority of the deed administrator.
Yeah, that makes complete sense.
So it's interesting, and I suspect, that there's probably going to be a lot more preference recovery claims in respect of claims made during a docker period.
Now that's been settled.
Now that's been clarified, because it's a very little known and very little utilised provision of the Corporations Act, which had received very little attention prior to our case. Although that said, there was a federal court case and a full federal court case which looked at it, but not in as much detail as we looked at it in our particular case. And that matter was heard before Justice Kelly Rees of the Supreme Court of New South Wales.
Wow, precedent setting again, Farid.
Well, no, it was, look, we just, when you look, I just take the view that when you're silk, you've got to look at these things properly.
Yeah, for sure.
You've got to do your best to make sure that you assist the court. And that's the way I approach these cases. And then that brings me to my third case, which is another case that was before Justice Rees of the Supreme Court. And I must say, this is probably one of my favourite. You know how you have favourites?
Yes. It's like Napoleon Purtis or Custom Bus for
pretty
Simon.
much, that's right.
The ones that he talks about at the dinner table.
Exactly. We all have our favourites, and this one was a favourite of mine because, again, it was actually quite unique, quite novel, and there was virtually no precedent. This was the case of, you may have heard of this one, it was the New Headspace case, the one with the NRL.
Yes.
The NRL.
Yes.
I acted for, amongst others, Todd Greenberg.
Right.
Who was the former, as you know, the former CEO of the NRL.
Oh, yep.
What happened in that case was Todd Greenberg and another NRL executive was served with liquidators' examination summonses.
Well, that's always fun to get those.
Always fun to get, and you name me one witness who likes to be examined in court compulsorily.
Mate, there's a very, very short list.
Isn't the instant reaction from anyone receiving such a notice, I've got to set it aside? That's
100%.
It's almost a natural reaction, isn't it? And a lot of the time, there's not much you can do about it as a recipient of these notices, because as you know, the powers conferred upon liquidators are actually
very wide-ranging,
quite draconian, as the High Court has recently confirmed. What happened in this case, however, was actually quite interesting. The director of the company in question had a long-running dispute with the NRL.
Right.
And the director of the company claimed that the NRL owed the company hundreds of thousands, if not millions of dollars. I won't go into the details.
We probably don't have time for that.
That's probably all you need to know. And there was a certain and the company and the company director was the sole director, sole shareholder, felt aggrieved by the NRL's conduct.
Yep.
What happened was that the director of the company sought litigation funding.
Yep.
And the court found that the company director placed the company into voluntary administration for the predominant purpose of, not for the purposes of
trying to get a restructure,
but, and this is what Her Honour expressly found, for the predominant purpose of empowering a liquidator to issue examination summonses to Todd Greenberg and others.
Wow.
And the court found that was an abusive process.
Absolutely is.
And in particular, also what the court found was this abusive process, this predominant purpose, was carried over to the liquidator.
Wow.
And Her Honour found that the liquidator did not turn an independent mind to the issuing of the examination summons. So we argued, the way we put it was that the abusive process rather of the actual voluntary winding up also infected the issuing of the examination summons. That's how we argued it.
And you got it set aside on that basis.
And we got it set aside.
Yeah, you're right.
So it's just one of those things where you just had to go back to first principles to try and work out an argument Because inherently you just, you have a gut feel to these things. Inherently it just felt like it was impermissible.
Yeah.
But actually arguing that point,
it's not easy.
It's actually quite a challenge.
Yeah. No, that's I can see why that's one of the favourites, Farid.
There you go.
Just in terms of, I guess we've kind of come a bit full circle now. You've been in the insolvency space for a long time. You're seeing what's happening in the market at the moment. What are your thoughts just generally in terms of where we're sitting 2022?
Oh, look, it really is difficult to say because we've been in such a strange environment. Look, you're in a better position than me, and I'd love to hear your thoughts. But the way I see it is that the market participants have been so sheltered from just ordinary, normal market forces.
Yes,
that it's only until very recently that market participants have actually been fully exposed to what's happening. And so, for example, from my perspective, when you look at the emergency and insolvency reforms that are put in place,
yes,
creditors were basically had their hands tied behind their back. They could issue a stat demand, but no one would bother doing it.
Yes,
it was technically possible to do that, but the reality is, if you had a 6-month compliance period with the statute, no one was issuing stat demand. Understandably, why would you?
Yeah, exactly.
And also, the reality was, even if there was non-compliance with the stat demand, the reality is you'll go before a judge who's going to be very sympathetic to any creditor, to any debtor company rather.
Sure.
Who's facing the prospect of having their company wound up in the most extraordinary of circumstances.
Obviously, it's one of those things that I'm not sure we'll ever experience again in our lifetime. I certainly hope we don't, but just having that moratorium period in place, as well as all the government support that came through and the amount of savings that went into people's bank accounts over that period of time, and even the changes to the way that we've lived our life up until now that are still, I guess, predominantly affecting it. It's just in terms of where that leaves us now and the market somewhat normalising, it's very difficult to try and predict what may or may not occur. Obviously, we've got interest rate rises, we've got inflation, we've got US inflation, we've got the Fed over there raising their interest rates to 0.75% in one hit, which is something that they haven't done for 40 years. All of these market forces, the construction industry, supply chain issues, we've got energy market problems now too, change in government, all of these things, something has to give, but what is it?
Indeed, I agree. And you add to that the war in Ukraine.
Yes.
Which is only, scarily, it seems to be escalating.
Yes.
That obviously adds to uncertainty, which markets obviously don't like. But certainly, look, from my perspective, I can speak from the perspective of litigation. There's been a market downturn in insolvency-related litigation.
Right.
You only have to you just do a quick search of the cases on litigation involving statutory demands, winding up, unfair preferences.
Sure.
There's a marked downturn.
Yeah.
I suspect that won't last. And once normal economic activity, whatever that means, once economic activity returns to if I can say, a less protected environment, then there's likely to be, at the very least, an uptick in that kind of litigation activity.
Well, you'll see that's coming through your pipe at some future point. I don't think it'll be too far away. We're definitely seeing in the last couple of months an uptick in creditor enforcement action. There's the ATO has issued a couple of winding up notices now, not a lot, 2, 3 maybe. I saw something in there with one of the big banks has started proceedings against someone there in the last couple of days. So and the appointments themselves, April, May, June are definitely trending higher. And I think it's coming down the pipe. It's just a matter of when and how much, and that's really difficult to try and predict. So, it's certainly interesting times for you and me in probably the next 3, 4, 5 years, because you get that initial shock a couple of years ago now. Usually after a recessional kind of shock, it takes a good 18 months, 2 years for the flow-on effects to start hitting my front doorstep, and then obviously a year or two after that before it hits yours. So
that's right.
It's certainly interesting in terms of that side of things. So Farid, we've gone through how you've got here, where you're at now. We've talked about your days back at the fruit shop. We've talked about your SC coming out. Well, we didn't talk about your party, which was very nice, I must admit. And thank you for inviting us. We've gone through all of that stuff now. We've seen and talked about where we think things are heading in terms of the insolvency marketplace. But what do you see in terms of things that are coming out of those types of appointments that generate interesting legal arguments? Is there any particular area that you've come across in your past or that you see is going to emerge on the back of obviously everything that's happened over the last couple of years?
Well, one of the things I've already alluded to is probably claims for unfair preferences made during a DOCA period.
Yes.
And also one of the other things which I think has been largely underexplored, and that's probably due to the COVID restrictions, is the expanded creditor rights under the insolvency practice schedule.
Yes.
Now, as a lawyer acting for a creditor, some obviously don't act for liquidators all the time, Andrew, unfortunately, but acting for creditors, you can see there is potentially a significant amount of scope for certain what everyone understands to be boundaries to be pushed even further. I don't think we've come even anywhere close to exploring the limits of the insolvency practice schedule and the quite extraordinary powers that creditors now have.
Yes.
In the context of not just liquidation, but just external administration generally, as you know.
To ask questions and get information.
Indeed.
Yes.
Indeed. And so that can be, when that's strategically adopted, I think it can be quite a powerful tool.
Yes.
Which was, on one view, so lacking in the past.
Yes.
And it will be interesting to see how obviously creditors and their lawyers behave, but also importantly how liquidators respond.
There's been some uptake in my experience, particularly from some of the statutory bodies around 70-45 notices and 40 notices. And you're right, the requirements for a liquidator to respond in that statutory period and the information that they're expected to put together within that period, which is quite limited, is something that is not easy in some circumstances for a liquidator to make sure that they're complying with. And obviously there's limitations and scope and things that you can point to say, well, that's unrealistic. How about you give me an extension for a period of time? But there is certainly a lot more power on the creditors from a creditor standpoint in terms of asking for that information. And you're right, strategically placed lawyers and advisors are going to be, once they get into providing or issuing these notices a bit more often, are going to be able to get access to information they probably wouldn't ordinarily have been able to.
Indeed. And also other things like, for example, expanding the scope for the calling of meetings, for example.
Yes.
So you can see how that could play out.
Oh, yeah. I've been involved in a matter where Simon actually replaced a liquidator on the back of one of those expanded scope meetings because the creditor had paid for the costs of convening the meeting. So it's definitely something that's being used, but you're right, I haven't seen it used to the extent that it potentially could be.
And of course, no doubt it will be abused, as these things often are. And that's how the law eventually becomes refined and explained. It's people testing the boundaries, rightly or wrongly. But these kind of cases, they actually lead eventually, can be an expensive process, but it does lead to some certainty when a judge is asked to confront some issues that arise. Yeah,
I think the other thing too that we may see a bit more of, particularly given what's happened in the last couple of years, is people accessing or directors accessing safe harbour or purporting to access safe harbour. And that hasn't really been tested at this point in terms of a set of proceedings, and I'm getting some sort of a resolution or some sort of judgment from a judge to say, yes, they were within safe harbour and therefore the directors are not in a position where they've got to deal with a civil insolvent trading claim. So I think that's another area too that will be tested in the short term, given what's happening across the economy at the moment.
Indeed, I agree. It's when you look at those reforms, even from my perspective, they're actually quite complicated. It does quite take some time to actually read through them and digest them.
Yes.
And again, I agree. That's another fertile ground for litigation.
For sure.
And again, I don't think we've even come close to testing what those limits of those provisions are.
No, I don't think we have at all either. I think that is where we're going to have to end it, Farid. Thank you very much for your time. It was a pleasure having you, and always great to get your insights, and always just nice to spend some time with you in from a personal perspective. So thank you very much again.
Likewise, Andrew. Thank you. Thank you for your time.
Thanks, everyone.